Uganda citizen, or indeed me as a foreign citizen, when I come into Uganda business or corporate entity that uses my data, what are the rights that is being afforded under the law? Okay, so under the Ugandan Data Protection and Privacy Act, and in fact, before I go into specific about the Data Protection Act for Uganda, data protection has been around a long time. It goes as far back as after the post World War II, when the issues of privacy became prominent worldwide. So data protection is not new. There are a lot of data protection laws across the globe. In Africa alone, we have over 34 African countries with either a data protection law or in parliament or under discussion. So Uganda is not on its own. And therefore, let's look at the specific of Ugandan Act. The main purpose, or to put in context, of Ugandan Data Protection Act 2019 is to protect the privacy of individuals. And it's done by regulating industries or people who collect your data. So personal data about you. It regulates that by providing things like raising awareness, holding controllers or organizations to task. And therefore, one of the things that are enshrined in the Act, apart from regulating how individuals' information are processed or managed by entities, it also provides for the rights of persons whose data are collected and processed. And when we talk about process, we are talking about those who collect, store, share, delete, do anything to our personal information. And then the same act also provides for the obligation of data controllers. So these are people or entities who are responsible or determine the purpose of the information they collect from you. So the obligation on one side enables or requires entities to do certain basic things. And therefore, with those obligations on the other side of the individual, it's the right that is afforded to individuals. So I thought I would give a summary of data protection principle. This is not just specific to Uganda, but in summary, every data protection act, and when we go back to the history of data protection, we have something called Convention 108, which is a document which outlines how nationals like Uganda, Ghana, Kenya, or other jurisdictions define and put their act together. Now, most of these things, or most of these principles, as we call them, which are enshrined under the various law, including the Ugandan data protection law, requires organizations to process your information fairly and lawful. So we then leads to the right. What do they need to do to make sure their processing is fair and lawful? It requires that they collect information about you and I, or citizens of Uganda in this case, for specific and explicit, what we call legitimate purpose. So they must have a proper reason to collect your information. And it also requires that adequate, that is enough, relevant purposes or reason is used to collect what is necessary to achieve a particular purpose. And they must keep the information accurately and where necessary, kept up to date. And one of the things I'm going to do is when I explain the rights of the individuals, I will also lead it to what organizations need to do to make sure those rights are upheld. It also requires that the organizations that are privileged to have you and I our information do not keep the information for longer than is necessary. And to top it all, whatever they do, the processing must be done in a manner that it gives security or provides security to the data you and I share with them for them to do their business or legitimate purpose. So that is a summary of what mainly data protection laws require organizations to do as the bare minimum. Okay, so I thought I will quickly touch on some couple of definitions. So when we start explaining the rights, it's really in sync. So we have some three key players in terms of Data Protection Act. Under the Ugandan Act, we have something called the Data Protection or the Data Controller. The Data Controller means any organization, so any entity, whether a sole proprietor or a multinational organization, who on their own or in jointly with other organizations have a common purpose or a statutory duty, determine the purpose in which personal data will be processed. So in a manner in which information will be collected, stored, distributed, or shared, or even deleted. Then when we go to the data controller on the other side, it means the person who actually collects the personal data. Then the third key player, which is very crucial, is that of a data processor. So a data processor, it's someone or an entity other than an employee who works for the data controller, but is empowered through instructions, through contracts, to process information on behalf of the controller. So I think these are the key things we're referring to. So the data controller will make a decision to go into a particular business and venture, and then they may collect the information through directly or indirectly, so a data controller. But the other third one is when they bring in contractors, when they bring in consultants to come and help them achieve the original purpose of that organization, they become the data processor. Another key one that all of us, perhaps when you start hearing about it, it's what we call the data subject. Today's session is all about the data subjects and then relating to what the data controller, data processor needs to do. So a data subject simply means an individual from whom or in respect of whom personal information has been requested, collected, collated, processed, or stored. So a data subject is you and I. A data subject is a student of an institution, a customer of a company, a client, or includes employees. So church members too are data subjects because information are collected about them. Citizens of Uganda or citizens of other jurisdictions are described as data subjects. If you're a member of an association and by virtue that you provide some information to that association or club, you are also as a data subject. By all means, this is not just the full list, but just to give you a flavor that data subjects includes almost everybody. In fact, everybody. And that includes you and I. And because it's about individuals, the Data Protection Act 2019, Uganda, affords certain data subject rights because we are natural people, we are living and breathing, and therefore we are empowered to have these rights. Okay, so this is just a sample right that you find globally. It's not specific Uganda. The next few slides will concentrate on Ugandan data privacy law. Okay, so we have something called the right to be informed, the right to give and withdraw consent, the right to access to personal data, and I'm sure you'll be very interested in that particular one. The right to amend, and if you remember in my introduction, and I brought in the principles, I sum up that they have to, data controllers have to keep information up to date, and therefore it gives the right to amend. We have the right to eraser, right to object, and we also have the right to freedoms for automatic decision making, where a computer makes the decision. The right to prevent organizations from using your personal data for direct marketing purposes. And we'll look at what is in detail in terms of how they can manage direct marketing. Right to what we call data portability. This particular one is not in the Ugandan Act, but you might come across it, so it's listed. A lot of the data protection acts have the right to compensation or civil proceedings, and also you have the right to complain. So I think at this point, I will introduce the rights under the Data Protection Act 2019 for Uganda. So in Uganda, we have the right to be informed. And in the previous slide, I think it was very similar. I introduced it. We have the right of access to personal information. Then we have the right to object. Now, under these rights to object, we have something to, which means we can appeal for a decision to continue processes. And I will take you through under which circumstances that can be done and in what the Office of the Data Protection Supervisor will do, or the Data Protection Office, what processes they'll follow if somebody should make an appeal. Then there is the right to prevent processing of personal data for direct marketing. And this is very similar to what is around globally, okay? Then we have rights in relation to automatic decision-making, which I showed on the previous slides. Rectification and amendment or correction, for a better word. Right to erasure and distraction. This is popularly known globally as right to be forgotten. Again, we will look into it more detail. Then you and I, because we are data subjects, we have the right to give consent. We have the right to complain and the right to be awarded compensation in certain circumstances, especially when the negligence of a data controller or processor or collector has caused damage or distress to us. Okay, so let's take the first one, right to be informed. Okay, so data subjects or individuals or citizens of Uganda have the right to be informed. And so it requires that a person or an organization that is collecting your information, your personal data about you, shall, and it means it's mandatory, there's no choice. They shall inform you, the data subject, about things like the nature and category of data being collected, the name and address of the controller or the person responsible for collecting the data, the purpose, whether or not the supply of the data is mandatory, which means when they give you the information, they should also explain things like, if you don't give us the information, what are the consequences? And there, I'm sure a lot of us have seen what we call a privacy policy before, but if you haven't, I hope at the end of this session, you begin to look at privacy policies in detail. So when you go to a company's website, a privacy policy will be telling you about the nature of the information being collected, what they are going to use it for, if they are going to share with anyone, if you don't give the information what it means, and spell out any rights. And this is because they are obliged to inform you on the principles I talked about, fair and transparent. It means they have to be transparent upfront. So you as a data subject, you have been given the right that anyone that approaches you either personally or through a form or web-based form or telephone conversation, or even a CCTV recording you, you should be informed upfront as to why that information is being collected, or at least signpost to where you can find the information. So this right is very powerful when it comes to data subjects exercising their rights. Every organization should inform you, and you as a citizen of Uganda, as a data subject, must be informed, and therefore you have the right to demand, if somebody is collecting your information, then you need to ask them, why are you collecting my information? What are you going to do with my information? How are you going to store my information? When are you going to dispose of my information when you no longer need it for the purpose? So who, why, what, and when? You have the right to demand those. And for entities or organizations that are listening, you have the obligation to actually put in measures to be able to inform the data subject upfront. So apart from the privacy policy that I listed, we have something called fair processing notice. These can be found on, for example, paper forms, and where it is outlined and explained what it is you are collecting the information. And like I said, if there are any consequences, make it clear But of course, data controllers or processors, it is not expected that you have a full 15-page privacy policy at the back of a form, but a summary of why the information is being collected, what it's going to be used for, and a signpost to where they can find further information. This could be a phone number. This could be a printed document explaining what it's going to be used for and handed over to the data subject, your customer, your client, your employees. Okay. And so when do we have to give this information? That leads me nicely to the next or small diagram on the screen. So you can collect individuals' information directly or indirectly. An example of a direct collection of information is when you give somebody a form to fill, or you talk to them on the phone and they share some personal information, or they go on your website and complete a form. So in that case, you are collecting the information from the data subject directly. And the law requires that at the point of collecting, this is for the data controllers and processors, at the time of collection, you must make sure there is mechanism to inform the data subject about all these things I'm discussing. And as a data subject, when you are completing a form and you cannot see any information explaining why that information is being collected, you have the right to ask them to explain. And this is the right that it's afforded under the Data Protection Act 2019, specifically Uganda, and indeed in other data protection laws across the globe. So you must insist, if they are not giving it to you, to explain. And no entity or no data controller should be able to challenge you to understand why. There is no a why in this instance. It's an obligation and it is your right as a citizen. So that's the right to be informed. The next one is what we call the right of access to personal information. So you and I, as data subjects or Ugandan citizens or anyone residing in Uganda in that matter, if your data is given, so at the beginning, I've talked about information, and normally you will share some information about yourself, your name, perhaps your date of birth, your address, your phone number, your email address. Once you've given it to the data controller or processor for a specific purpose, which they have explained at the beginning of collection, what will happen is they will store your information on a database, on a file, in a book somewhere. And therefore, they have custody of information about you. So what this right afford you is that when you provide proof of identity, you have a right to request that these entities, these companies, these institutions, these schools, this bank, to be able to confirm to you in writing if they have any information about you, what sort of information they hold about you, and indeed even request a copy. Now, the Act requires that data controllers or processors, so the companies, the individuals that collect your information for business or commercial purposes, requires that they confirm within 30 days whether or not they intend to fulfill your request. So for companies and organizations listening, you need to have processes in place to ensure that when the data subjects, when your customers, when your clients, and indeed your employees ask for a copy or ask for you to confirm the information you hold about them under the right of access to personal information, you need to have processes in place to allow you to deal with this request within 30 days from the date of request. And that is not 30 working days. This is 30 days. Okay. If you intend not to comply for whatever reason, then you must still confirm and give the reason for non-compliance. This right can be exercised by anybody at the same time. So organization listening, please get your house in order, because I'm suspecting after this webinar you'll be getting a lot of requests, but I do have confidence that you began putting things in place. And so the right of access is a very powerful one, because one, you need to locate the information as a business. Then you need to perhaps look at the information that can be shared. And sometimes information such as business confidential information may not necessarily be available for sharing. If you do have other third parties information in a record, for example, if you're sharing a file that has got another data subject information, you will need to remove or get the consent or permission of the other third party before you can share. So you have 30 days to do all this. And the advice I will offer to data controllers and processors that request the application in writing. And under the regulation, they have actually added a schedule, which is Form 8, which you can find in the regulations for the Uganda Data Protection Act. And that form can be used to request a copy or information under the Acts. You must always have measures in place to prove that the person requesting the information is indeed the right person. Otherwise, you might end up disclosing other people's information to third parties, which in itself is a breach of the requirement of the law. You will have broken security. So any individual, to be able to exercise this right of access, the right that you can exercise to get a copy or indeed confirm information that an organization holds on you, you can use the Form 8, which I believe is available on the Data Protection Office. You must be prepared to share an ID document, such as passport or a customer ID or national ID, if that is the case, so that they can verify that you are who you say you are. Organizations must give directions, which is good because you may hold a customer data going back 20 years. And I hope it is in line with what we call retention, because when I explained the principles, I mentioned something like it must be kept up to date and no longer than is necessary. So if you've got information going back about data subject, do you have a legitimate reason to even keep it? So begin to give guidance so that when people request for copies or information, you are clear on what they are looking for. For example, they may be looking for only emails. They may be looking for telephone conversation. That is, if you've recorded it. If you are recording your telephone conversation as part of your business process, if I want a copy of that telephone conversation, are you in a position to give us? That's a question for organization to start thinking about. Okay. These rights, it says you have the right as a data subject to prevent processing for direct marketing and right to object. Now, when we talk about direct marketing, we are talking about when you send email marketing about or promotions about your product or services to people. They may not necessarily be your customers, but if you market or send them promotional messages directly to them, the law says the data subject have the right to prevent you from doing so. Which means if you have got or you are marketing or communicating to me and I've not given you consent, and I think it's good for me to say what consent is. Consent is a means of obtaining permission which is freely given by the data subject. So the data subject is not forced to sign, to say yes, or to tick a box, but the data subject has the choice because what? You will have informed them about the processes and why you're collecting the information. If they are not happy, then they have the choice to say yes or no. Now, if for any reason they have not been given the choice, or they've given the choice and didn't realize, they have the right to come to you, the controller or processor, and say, can you stop sending me marketing materials? So for example, sometimes you get messages on SMS, sometimes you get emails in your inbox and you're wondering where you got it from. As a data subject, guess what? the law is giving you the power to stop organizations from doing so, especially if it's right, it's for direct marketing. Now, you also have the right to prevent or right to object and telling organizations to stop processing your personal data, not only for direct marketing, but where the processing or the activity, the collecting, the storing, the deleting is likely to cause you what we call unwanted or unwarranted substantial damage or distress to you, the data subject, where there's no legal basis. What is a legal base? A legal base is what is afforded under the law. I started by talking about the obligations that controllers and processors have. One of the requirements or principles says that they must have a legal basis. A consent could be a legal basis. Sometimes there's a statutory duty. So, for example, information required by government agencies under certain law. So, to give an example, if you're an employee, the government or statutory body requires that certain information is collected from you for the purposes of paying into either national insurance or pension and so on and so forth. They have the right to also object, where if you continue processing their data, it will be different, or they believe it is different from the original source. So when a data subject or you and I give information, let's say to open a bank account, the purpose of opening the bank account is why I will give them, or you will give them, your name, your postal address, maybe your email, your date of birth, maybe your next of kin, and so on and so forth. That is the purpose, to open a bank account. Now, when they decide to market, for example, insurance services to you, and you are not interested, this is where you can say, what you are doing, I'm not interested. You are processing it further or in addition to what I told you or what I gave you or what I understood you were going to use my information for. Therefore, I have the right to tell you to stop doing that. A data controller in this instance have 14 days after the time that they receive the notice from you to tell them that they should stop and you do not agree with the processing. And however, if you request that they stop and they come back within 14 days and say, for one or two reasons, we are going to continue processing. If you are not happy with that decision, you can then escalate into the office of the data protection, so the data protection office in Uganda, and lodge an appeal, and they will do a further investigation. So we have powerful rights. So if you are being bombarded with direct marketing, this is the time to begin to act. For controllers, how you can manage this is have processes in place. When individuals exercise this right, what you will need to be doing is have processes to ensure the record is marked, maybe inactive, where it needs to be deleted. We'll talk about distraction in a moment, but how you're going to manage it. Okay. You also have the right in relation to automated decision making. Simply put, when a company or an organization is making decisions based on algorithm or formulas or scores or computer saying yes or no, in these days, artificial intelligence will begin to learn your behavior or machine learning, and therefore they profile you or they put you in a bucket and you begin to get information, or you apply, for example, for a loan, and I'm sure the banks or the financial institutions have a way of assessing whether to give you the loan by looking at your risk structure. So this right says, when a company decides to use automatic decision making, they should have processes in place for you to be able to, if you question it, for them to have a human intervention, so that this information is not solely on automatic decisions. So imagine you are completing a form and they've asked you to answer, are you married? And accidentally you put no or yes. and they ask what is your job title, or your gender, for example, and you put male, and this product is for females, and so they say no, you can't have this facility because you take X, Y, and Z. You have the right to go back to that company and say, can you review that decision you've made based on automatic means, based on artificial intelligence, or whatever process they are using to assess? So you have a lot of rights, and data subjects, you're as powerful as we can be under this Data Protection Law 2019 in Uganda. So I'm talking about how you can intervene and ask for human intervention. The law provides that the controllers and process or entities that have your information, if you are basing it on automatic decision making, they have 21 days when you exercise that right to come back to you and tell you whether they are going to deal with it or not, and the next steps that you can follow. Okay, we have the right to rectification, blocking, and eraser. So the right to rectification, it simply means you and I have the right to correct inaccurate information about us that they may hold. If an organization has too much excessive information, you and I, or data subjects, citizens of Uganda, students of a university or school, customers of a bank, members of a church, members of clubs, customers, have the right to say, you've got excessive information, can you collect it? And they can block you from further processing. They can also ask companies to delete or erase our information. Let me explain this bit because this is very, very interesting in every jurisdiction. It is also known as right to be forgotten, and I'm referring to eraser. An individual who has given their information to an organization, a data controller or processor collector, that finds that the information that being processed or after a period, for example, is inaccurate, there is no legal basis, and I was trying to explain legal basis very quickly. There is no reason, there's no legitimate purpose for them holding the information, or it's out of date, it's not correct, it's misleading. You can ask them to delete that information. Now, I need to add that deleting information cannot be an absolute right. It has to meet some conditions. So if the information is incomplete, there is no reason for the organization to have it, you can delete it. However, the organization will have something called their own retention policies that can be guided by law or their own internal policies. So for financial institutions, imagine going for a loan at a bank and perhaps you haven't met your payments and you don't want to pay. You cannot go and exercise your right and say, delete my information, because the organization will have an overriding, what we call legitimate interest, because they have to recoup their money. So in that instance, they may refuse to delete it. But if there's no reason, there's no backing legitimate reason, then the organization can say, no, we won't, but you can still appeal so that it can be reviewed. However, if you can prove, if there is evidence that the information they hold is inaccurate, for example, you never bought anything from them, that is inaccurate, you can delete it. The information is holding is not incomplete, it's not a true picture, you can ask for them to delete. If it's out of date, you purchased something 10 years ago, you never gave them consent to continue sending you marketing material for direct marketing. And so you have no reason why you should be receiving marketing from them. Their own internal policies actually says they keep it for 6 years. And it's been 20 years and you've been getting things in the post and also being emailed. If you do not want them to continue, at this point, you can exercise the right to eraser, also popularly known as the right to be forgotten. So remember, data subjects or citizens of Uganda, you have the right to correct your information, to block further processing if it's not in line with what you gave them, and ask them to erase it. Now, this is a very popular one. I've been talking about exercising your rights. You and I, as data citizens or data subjects, you have the right to complain, and furthermore, right for compensation. So how do we complain, and what do we complain about? You complain, one, you can complain to the data controller, the data processor, data collector, or if nothing has been done about your complaint, then you can complain to the Personal Data Protection Office. So which means when you complain, I will urge you to have a record of it. Organizations also need to keep a copy of the complaint, just in case you have dealt with it and the data subject is still not satisfied. Even if they are satisfied, you still need to keep a record. So you and I are citizens of Uganda. I'm talking to you today. You have the right to complain about how an organization manages your information. And furthermore, you have the right to compensation. Now, in which circumstances can you get compensation? And I don't mean if you're just getting marketing material, you go and hire a lawyer, expensive lawyer, to come and claim compensation for you. However, where you have suffered distress as a result of the contravention of the data controller, as a result of the negligence of the data controller or processor or collector, they haven't done something right. They have not looked after your data securely. And so somebody has managed to access your information and has caused you damage. Then you can apply to a court of competent jurisdictions. And I'm hoping by the time you get to a court stage, you have gone through the complaint processes. The Personal Data Protection Office will have done their investigation to confirm that indeed a contravention has occurred. Then you can go to a court of competent jurisdiction to make judgment for compensation. And like with all compensation, they will look at the merits of the case. And I can say that if the Personal Data Protection Office has confirmed that there's been a breach, that will be something, a defense or an evidence you can take to court, and the court will decide what exactly the level of compensation you are afforded. Now, right to give consent. I started by trying to explain what consent, okay? Under the Part 3 of Data Protection Act 2019 in Uganda, it says you must collect or take consent when you're collecting individuals' information, unless, of course, there's other reason like a court has instructed that it should collect your information, or you are going into a contract with a company, therefore they need to collect certain things. So you have the right to give consent. And when you are giving consent, it is as simple as saying yes or no, or ticking yes and no that can be recorded as evidence, ticking a box, signing on a piece of paper. Now, for organizations, you need to make sure this is clear. This is optional. There is no condition based on this. You cannot ask the data subject to give you consent before you can do something. The consent must be solely or separately from the main purpose of processing. If, for example, you want to continue giving them marketing material, then you must give them the option to say yes or no. If they don't say yes or no, you don't take it as a yes. You take it as a no, unless the data subject have said, yes, I want you to give me or send me promotions about particular products, not anything. You haven't got consent. So you and I, or citizens of Uganda, you have the right to say yes or no, especially when it's an additional purpose to what you're originally going for. You are buying something, of course, they need, sometimes if you want it delivered, for example, they will need your address or something like that, or email address. But if you are buying something from a supermarket where you just pay, you shouldn't be asked, or if they want you to be part of, let's say, a royalty program, or they want you to be part of a marketing campaign, then you should say yes or no for that extra things. Okay, I think that brings me to the end of the presentation. I can see there's some messages in the chat. So I'll pause here. Anita, I'm not sure whether you want me to go through the rest of the slides just to give some background as to what we do in my company, or this is the time for questions.
Yes, Livia, I think you can briefly do that and then we do the questions.
Thank you.
Okay.
So we did a quick introduction about who I am. I am actually a CEO and a lead consultant from a company called Information Governance Solutions. And I'm proud to say we have been accredited by the Data Protection of Ghana. And what we do is we provide data protection services across Africa, and including Uganda. So we are hoping to be able to assist companies on the compliance journey in Uganda when the time comes. So all we do is we provide data protection and cybersecurity services. We are registered in Ghana. This is an overview of our services. So we provide data protection consultancy services. So for example, we can come in and do an internal audit for you, or indeed external audits if the supervisory authority or the data protection office requires us to do that on your behalf. Registration and renewal. So for example, in Ghana, there is a portal for registering data controllers and processors. So we can assist in that, similar to Uganda. We offer cybersecurity services and training. We are implementers as well. Myself, I'm an ISO 27001 implementer and auditor. That's relating to information security. We provide training and awareness at all levels, from the CEO to the person at the security gate. We do managers, employees, and we tailor it to every jurisdiction. So for example, if you have to deliver for Uganda, the training will be about the Ugandan data protection. But we always add other jurisdictions because we are aware that some companies operate in more than one. So that's what we do. Our flagship training is a DPO training, which is the Certified Data Protection Supervisor. So we offer training to organizations or to individuals who can become certified practitioners. And in fact, this week we are doing something like that. We can come into your organization and do a gap analysis and let you know your current state of maturity. Okay, because compliance is a journey, and so that's what we do. We can also provide a service. So if you're an organization that needs somebody to represent you as a data protection officer, go nowhere but Information Governance Solutions. We would then be assign one of our consultants who work as your in-house data protection officer, including access to a helpline. So these are the training areas. I think I've talked about it. So we have general areas of our employees, different functions. So for example, specific for HR, specific for IT, finance, maybe project managers, heads of department, and so on and so forth. Then we have the specific. We have privacy management. We can train on audits when we cover Africa and Europe as well. So in Europe, myself, I'm certified practitioner to the European standard IAPP. So we can deliver GDPR. If you find that you're operating in Europe, we can do training in those areas. Our training formats are either classroom-based, in that case, if it's a Uganda-based company, then we'll be able to come and deliver face-to-face, or you can join one of our training in Ghana. We also offer online, which means anyone can join. And for example, our practitioner training, although it is primarily based on the Ghana law, it covers the basics of any data protection law. We have e-learning and we also have a blend approach. Okay, so these are some of the services we provide. And I think I've already talked about it. We can do a DPIA, which is the Data Protection Impact Assessment. And I know the Data Protection Office has already done some awareness raising around DPIAs, but we can actually help you do one. If you are doing due diligence on a third party, because as a data controller, when you bring in a third party, you have to do some due diligence to make sure these third parties also complied with the law to assist you in also complying. So you don't get a third party coming in where they are not compliant, which can lead to you not being non-compliant. And this is our contact if you need to get in touch. I'm sure the Data Protection Office will be sending the copies of the materials to you, so you can reach us through there. And I think this brings us to the end of the presentation. And so thank you very much for giving me a listening ear. And I hope citizens on this call, you're empowered to exercise your rights. And I hope organizations, you are ready to put in measures to address the rights of individuals, in addition to all the obligations that is required under the Data Protection Act 2019 in Uganda. Thank you.
Okay, thank you very much, Sylvia. We are definitely empowered. We have about 10 minutes to go, and we are going to go to the questions. I am going to start with the questions in the Q&A panel. Sylvia, would you prefer to answer a question at a go? I read one by one. Sylvia, you're muted.
I think that might help, unless, of course, if you decide to answer that.
All right, so there is a question here. Please elaborate on automated decision making, giving some examples.
Okay, automatic decision making is where an organization decides to use, for example, a scoring mechanism. So you answer yes, it gives you 2. You answer no, it gives you 0. And by the time you answer certain questions, then based on the results, the organization will say yes or no. So the decision is not made by a human being reading your answers and reviewing it, but it's built at the back of a system. We have something called algorithm. That simply means formulas in a system that will score. It's a little bit like profiling. If you answer this, you are in this bucket, and then a decision is made based on that. Yeah, so that is automatic decision making. And as a citizen, yeah, you can exercise the right to ask for the organization to review the decision based on that.
All right, thank you, Sylvia. Next question. What sort of proof should a data subject request sufficient enough to present in case of a complaint and a controller can't deny ever controlling that data?
I think this is the best questions, and I was expecting this. It's not difficult at all. When you do complain, put it in writing. If it's an SMS, keep that. Take a screenshot and save. If it's an email, keep it. If it's a paper, take a copy and keep. And take, hopefully all organizations, good organizations, will have either a number to call or a website or a form to fill. Make sure you send it to the right channel. When I say the right channel, it means anybody that is an employee in that organization. If you give it to them, you have submitted it. Ask them to give you a name of who you've given to, and make a note of date and time. Keep a copy of your complaint. If you ring to complain, if you don't have a recording, in fact, you might not be able to substantiate your complaint. The burden of proof is on the controller to prove that you haven't complained, but you also have the responsibility to keep a proof. So that it doesn't have to be, when I say in writing, it doesn't have to be a long letter. It could be a text message. If the company is communicating by a social media platform, if you put something there, it's in writing, but keep a copy of that complaint.
All right, thank you very much. That answers you, Kenneth. Another question is about, can a data controller comply to the data access request in a period of more than 30 days of writing back to the data subject by confirming they received the data access request and are in the process of complying and they tend to comply?
I think my answer to that is about your complaint management process. If you find that for any reason you're going to be longer, what I would say to a controller, don't wait until the 30th day before you write to the data subject and say, oh, we need another week or 2. manage your complaint system. So if I were you, I wouldn't make my processes 30 days. I will make my processes 21 days to allow me the extra 9 days for the activity. Because remember, you have to go and find the information. And it could be paper files that you have to remove, posting notes and photocopy and take things out and hold. So it's about managing your complaint system. Make sure you respond and keep the data subject informed within the 30 days. But if on the rare occasion that you are exceeding the 30 days, engage with the data subjects. If somebody complains, a lot of the time, the reason why the complaint is escalated is when people don't respond. Then you aggravate the data subject. So manage your data management or complaint system. 30 days is the statutory one, but I'm sure the Data Protection Office will not reasonably penalize you if you haven't met the 30 days and you have explained to the third party in good time that it may take longer. But when you go back, you must have an indication of the timeline. Don't say it's going to be over 30 days and it's a year. That will not be reasonable. Okay.
Yeah. Thank you, Sylvia.
Welcome.
21 days is smarter.
It's matter. So if you don't meet 21 days, you have 9 days.
Yeah. Another question is, what are the exposures under the Ugandan law for companies storing data on clouds?
Okay. So I hope I understand the word by exposure. If you are referring to risk, putting things on cloud is not necessarily stricter. It's what you do about the process that matters. So for example, if you decide to store on a cloud, and a cloud is actually storing your information on a server in a physical location somewhere. So if you are storing, for example, on your cloud, which is based in, let's say, UK, and the cloud provider who is a processor, it's a processor because they are storing your information for you. So they are helping you store your information. They are doing something on your behalf. You have to have what we call data protection agreements. You have to also be aware of where the physical server is. And there are a lot of measures that you have to put in place. So for example, I talked about due diligence of a third party, making sure that the cloud provider is indeed complying to data protection laws, complying to security measures. You don't want to give your data to a cloud provider and then you go and visit them or do audits, only to find that the data center is actually in somebody's garage. What happens when there is a flood? So it's about due diligence. Yes, there is a risk, but you can do due diligence and put mitigation processes in place. And start by understanding your security around where the data is stored. So if the data is stored in a location that it's outside Uganda or indeed Africa, then you need to have these things in place. But how you do that, I think it needs to be addressed in terms of the particulars of a particular situation. So organization, if you ask me this question, I will have to understand a little bit more about the background before I can advise you. But in a nutshell, you have to do a risk assessment around it, that is a DPI, and know where your data is being stored and be comfortable that it's secured and it's allowed. It is called international transfer. You are storing information outside Uganda. So know where your cloud provider is storing your information. I hope that is the question, because the exposures, I wasn't sure what you meant, but I hope you were talking about the risks. If it's not, you can clarify.
Okay, thank you, Sylvia. I hope you've been answered, whoever asked that question. Let's move on to the next question. We still have many questions to go. Do organizations in Uganda complete data protection impact assessments before they onboard new service providers?
I think the answer should be yes. Now, why am I saying it's yes? When you are onboarding a service provider, the service provider is presented or coming to do something for you. They are going to provide a service. So you do the DPI around the service or the activity or the process, not necessarily the third party. Now, as part of your DPI assessment, what you will do is you will assess security as part of the principle. So your due diligence, and we have something called data processing or data protection agreement, which is the contract that must be added to the initial contract. So that is how it works. So a DPI is not on the third party, it's done on the activity, the process, or the project. That's how you do a DPI. But as part of the DPI, so a DPI is really a risk assessment about the process or project. And if you are going to use a third party to assist in delivering that service, then you will do a DPI on the process or the service. And as part of it, you will do the due diligence about the third party. So you don't do a DPI on the third party.
Okay. All right. Thank you, Sylvia. Another question is asking do you carry out PCI/DSS compliance services?
We can get, we have a lot of consultants in our book. So that is for organizations that take money. PCI DSS is for organization or a standard that if you are taking like credit cards or payments, you must do. We can provide you that service. We have a consultancy, consultants on our books that can help do it. Yeah.
Okay. All right. Thank you very much. It is already midday, but I think we are going to continue and take just a few questions if you really do not mind, because we still have lots of questions coming.
If they are happy to stay on, I am happy to stay on for another 5-10 minutes.
Okay, then, thank you. Moving on, another question is, does an employee have the right to access their personal file, which may in essence contain information the organization would not want them to access?
My answer, I'll start from the back. Why don't organization wants you to access? And this is advice to HR organizations: only record facts about your employees. Yes, an employee is a data subject, and therefore they have the same right. They can exercise it at any time with no questions. So to make sure you don't share any information that you don't want to share per se, is to make sure you only put facts on their file. If you are saying things that I don't like this employee, guess what? When they ask for it, you have to share. However, if they are business sensitive information like formulas or business strategies, then under intellectual property, you're allowed to take it out. But yes, every individual, employee, customer, client, you have the right to access, and it should not be penalized because you are asking for it.
Okay, thank you for that. What happens if the data collector refuses to disclose the use of my data?
Well, first of all, you have to exercise your right to the information or the right to access. And like I said, with all complaints, if they haven't dealt with it, you go to the Personal Data Protection Office and complain, and they will investigate. This is a right to data subjects. No data controller can deny you that. Now, based on what I've explained earlier, they cannot, and they are not allowed to deny you that. But if every month you're going for a copy of your file, then they have the reason to say no. And so for organizations, when you provide access to individuals or data subjects, what I will urge you to do to have a log. I'm not saying keep a copy of the information, but have a log of who you've sent things to, what you've done. So we have something called vexatious requests. There are some people, they will come every month. And if you can prove that you've already provided them that information, then they can deny. Other than that, you cannot deny a data subject, whether they're an employee, a customer, a client, a church member, or a student.
All right, thank you very much. The next question is, does this right to decision making give the data subject a right to participate in the company's decision making on technological transformation?
I don't know if I understood the question. Is it about automatic decision making or decision making? It's about automatic decision making. It's not about company decision making. Let's get this right. If you are talking about automatic decision making, it's about automatic decision making that will affect you as a data subject, not the company's decision. I hope that is what the question is about. It's about automatic decision making. It's not about decision making. So let's not take the automatic out. Otherwise, it becomes a different discussion altogether.
Okay, thank you for clarifying on that, Sylvia. The next question is, how do you handle a client who wants to be forgotten without any of the reasons you suggested? The client is just uncomfortable about their data being stored by the business.
If there is an overriding business reason or legitimate reasons, for example, you're continually providing them a service and the client still want the service, you can't forget them. If you have your own internal rules, for example, I mentioned retention. There are retention rules in different industries and different companies. So if, for example, the financial industry requires that information is kept between 6 and 7, and please don't quote me on this, but I'm giving an example. If they say 6 years and you come back 3 years and say right to be forgotten, the data controller should go back to the data subject and say, thank you very much for exercising your rights, which we are willing to meet. However, we are bound by X, Y, and Z to keep the data for 6 years. So we are going to mark your information as inactive. And at the end of the retention period, we will delete as requested. Otherwise, you might be deleting prematurely.
Yeah. Okay. All right. Thank you so much for that. There is another question here. Shall we be complying if we printed and hung the data privacy notice in our banking hall? It
is a good start. But privacy notices are normally not one page. So I don't know how people will be able to read that whole notice before they go and cash their money. But it's good practice to put a summary, one pager, framed nicely, and say, we look after your data, or this is why we are collecting your information. We may collect it when you come and withdraw money because we need to identify you, or open account or other services. If you want to know more, contact our DPO. It doesn't have to be a name person. It could be a shared inbox or a phone number. Contact us or visit our website, www.whatever the website, and read it in full. If you want to even become more compliant or more, in fact, more transparent, you could print the privacy policy in a leaflet and leave in your reception so that people will take away and read, because there's no way people will stand at the forecourt of the bank and read, even if it's 2 pages full. And the law requires that you make it transparent and easy for them to read. It's very good because actually I saw something like that at an airport. I'm very intrigued. They had it framed at the airport, but then they had the extra messages. So as you're walking through, you see them, but you don't stop to read, but at least you see there's something, and they've made it very bold. Wow, you can find out more information. So that's a very good practice if you want to do it, but it's how you do it.
Okay, thank you very much. The next question, kindly explain whether subscribing for a service or an app automatically means consent to hold my information.
No, it doesn't. When you are subscribing to it, well, okay, let me break it down. If you are downloading an app and you're subscribing, normally there is a terms and conditions. So terms and conditions is different from consent. However, if the app wants to send you other things apart from what the app is to be used for, then they need a separate consent, so it's not the same. The app will always have a term conditions or a privacy notice for you to read, which a lot of us don't read, but it doesn't mean it is consent. It is really giving you information. So when you look, they are meeting the right to be informed. However, the consent must be separate. It must be clear and concise in a language that you can read and understand. A lot of the time, the terms and conditions are very small fonts and they are 6 pages. That it's not valid consent. So no, there are differences.
Perfect. Okay, the next question is, we already have clients and customers' data in our databases. how do we go back to seek consent, yet we've been using this data over the years? Please guide me on how this can be handled at this stage.
This is a consultancy question. However, what you can do is the next time you contact them, put your consent statement in the communication and ask them to give you consent. If they don't give you consent, I'm afraid you've lost them. You haven't lost them for the purpose of the original services they are subscribing. But if they don't answer, then you can't for example, do direct marketing to them. So you can write, I wouldn't say just send a communication for the consent alone, because what happens is, this happened when GDPR came in, a lot of organizations were doing that. What you would do is the next time you communicate, put your consent statement in the email or in the letter or phone number and obtain it at that point. So eventually your whole database will have accurate consent, which you can use to prove that they actually gave you consent. So you can put things like unsubscribe. But however, the reason why I'm saying put in a consent statement rather than unsubscribe is that you must give consent in the first place to unsubscribe. So if I haven't given you consent, how do I take my consent back or withdraw or unsubscribe? So the next time you communicate, put a statement in a simple, you can contact us for a guidance on the type of text that you can use to reconsent as it's known.
Okay, thank you very much, Sylvia. I have still about 2 questions to go. So someone is asking, on a marketplace like Amazon, how does a company manage privacy and marketing to customers of the merchants who buy stuff?
The merchants, I'm getting people, I'm guessing people have different names. So when they go to that platform, when they're buying it directs them to either your site or something. And so Amazon will have its own privacy policy, which is addressed to data subjects in terms of how the information will be shared. So example, Amazon privacy policy should say something like, your details will be passed on to the merchant who is going to ship this information. So that will be good. So you might want to go to Amazon and ask them what privacy measures they have in place. Now, Amazon is a very big organization. So in terms of writing and giving you your own terms and conditions might not work, but they should have standard processes around how they manage it. And if you are marketing on Amazon, for example, the marketing activity, like I explained, that you don't do DPI on the system, you do DPI on that marketing on Amazon. So as part of the DPIA, you would then need to do have these things in place. So managing will be you and Amazon, but I am pretty sure Amazon has some standard procedures. And so if the customer is signposted to your website, when they come to your website, you do have the consent, their privacy policy there. If you need, a lot of the time when people buy something online, you are not relying on consent because it is what we call a contractual obligation. The customer is buying something by paying you and expects you, the merchant, to provide the service. So it's a contract between the two. So that will not be consent. It will be a contractual obligation. So all these things need to be mapped internally in what we call your record of processing activities. I can see a lot of you who need my help, so please reach out.
They will definitely reach out. Okay, so the final question is, what are the requirements from the Ugandan government in terms of compliance to the Act? Do they require all organizations to conduct DPIAs? I think we had talked about something almost similar to this. And does the Ugandan government require us to have policies in place?
Okay. The Ugandan Act requires that you do some sort of risk assessment. Now, in best practice, DPIA are not done on every single thing. When you have large volumes, when you have sensitive information or technology, these are some of the conditions. This is why you need an internal DPO who has been trained and understand when to do it. So my advice now, because the data protection law is fairly new in Uganda, you do not have an awareness of the risks around the activities you undertake. So I recommend you do high-level assessments on all your processes. Now, for you to demonstrate compliance to the law, whether you do a DPI or not, you need to be able to demonstrate to the Ugandan authority when asked or when demanded that you are complying. And how do you evidence that? By doing risk assessment, which is a DPI, so that you can understand what needs to be done. So if you do a risk assessment, for example, on the Amazon marketing process, and you realize you don't have a privacy policy, you are just adding people to your database and continuously marketing to them, the DPI will identify that you need to add consent statement before you are marketing. So yes, even if it's not required, and I'm not saying it's not, it is. If it's not required, how do you determine the risk around your activity? You haven't got a choice but to do a DPI. Yeah.
Okay, thank you so much, Sylvia. Members, for those of you that were asking for the presentation, the recording and presentation are all going to be shared on your emails. Sylvia, we are very honored to have you. Thank you very much. The presentation was very informative and educative. I know members are still burning with questions, but let's keep the conversation flowing on our social media and you're going to be answered. Thank you very much. And with that, I am going to close this webinar.
Thank you very much. Thank you.